I want to talk to you today about one of our fundamental rights under the Canadian Charter of Rights and Freedoms. And this is Section 8. Everyone has the right to be secure against unreasonable search and seizure. What does that mean? Well, it means this simply. The police cannot search you unless they have reasonable probable grounds in most situations. That's the general rule. There's a lot of deviations from that rule. So what does reasonable probable grounds mean? Essentially, for example, let's talk about a house. To come into a house, by the way, the police need reasonable probable grounds outlined in a search warrant to enter that home. If they don't, for example, they go to a justice of the peace and the justice of the peace reviews the affidavit of the officer setting out their grounds, the justice of the peace might say, well, there's not sufficient grounds here, and I'm not going to issue the search warrant. That's what, if the justice of the peace understands the law well and understands that that affidavit doesn't provide grounds, they should not issue the search warrant. Now, let's say the justice of the peace makes a mistake and there's not sufficient grounds. Those grounds can be attacked in court. It's called a Section 8 charter application. And what you'd be doing as defense lawyer, say there's drugs found in the household, you'd be bringing a charter application under Section 8 to exclude that evidence, arguing, look, there were not sufficient grounds to enter that home. The only thing the police had was an informant's tip, for example, that was not verified for anything, by anything. It was an unreliable informant, just as one example. There's so many examples of this in every context. Border searches, by the way, the level of reasonable grounds is more reasonable suspicion at the border. It's a much lower level test. But say you come up to someone on the street, the police just can't start searching the person. They need grounds to search that person. There's a lot of case law on this topic. A good defense lawyer can review your particular situation once he or she receives the disclosure and figure out, were there sufficient grounds? Can we attack that search warrant? Can we attack the search? Can we win your case? And when you think about it, there's so many situations in Canadian law where contraband's found on someone, where drugs are found on someone, when we enter a household. This is such an important fundamental right. The police just can't start breaking in your home without proper grounds. And if they do, you're entitled to attack that in court as not being reasonable. And we enjoy that great right in our great democratic country. So if you're facing this situation, you've been charged and something has been found on you, make sure that you hire or retain a competent criminal lawyer to review those grounds to see if you have a defense and can win your case under the Canadian Charter of Rights and Freedoms to exclude the evidence. And that exclusion section is Section 24.2. That's one of our most important rights in Canadian society, frankly, is the right to be secure in our own homes and to be secure on the streets.